Bismillahirrahmanirrahim. My dear brothers and sisters, Assalamu alaikum warahmatullahi wabarakatuh. So this is part 4 of my video lecture on the topic of state territory. And I was discussing in part 3 about the Palmas Islands case and the application of intertemporal law, and then concluded that since Netherlands could prove that it had sovereign activities just immediately before the critical date, Netherlands won the case, and then Netherlands owns the Palmas Islands case, not Spain or not America, which is the successor state of Spain. So this case very clearly explained about the Judge Huber's application of the intertemporal law. So not the original intertemporal law, the intertemporal as amended by Judge Huber to be applicable to territorial dispute. This intertemporal law, the new version of intertemporal law, is applicable in territorial dispute, which is not the same with the original intertemporal law as explained by Sir Gerald Fitzmaurice. I have already explained to you before. Okay, now this Judge Huber, this extension of the concept of intertemporal law has been criticized, especially by Western countries, because they are scared that the colonial states, especially the colonial countries, they are scared that their titles to the colonies will be endangered, because the colonialism was, in the past, it was lawful, but according to the UN Charter, it was not lawful. It is current international doesn't that very clearly say the use of force by means of use of territory cannot be acquired. So that's why they are very worried. But anyway, what Judge Huber stated in the Palmas Island case is correct. From the legal point of view, it is correct, it is logical. Even Professor Brownlee says the extension of the doctrine is logically inevitable. It is inevitable. But practically, from the practical point of view, it is necessary to be careful in applying the rule. Not to anger the many Western countries at the time, and not to anger many Western countries whose title will be affected, whose colonial titles will be affected by applying this doctrine. But anyway, the doctrine is correct, and we have to follow this doctrine when answering territorial disputes, questions. Okay, now we move on to the second mode of acquiring state territory, prescription. Prescription. What is prescription? Definition. The peaceful and continuous exercise of sovereign activities for a long period over territory subject to the sovereignty of another state. This is the definition. From the very beginning, I give you the decisive factor in territorial disputes as between in occupation and prescription is the peaceful and continuous exercise of sovereign activity. This is the same. This is common factor in both occupation and prescription. This is common factor. But the main difference is, for occupation, it must be terra nullius. But for prescription, not necessary to be terra nullius. The territory can be subject to the sovereignty of another state. Another one extra point is that prescription can be applied. Prescription can be, relying on where the exercise sovereignty is for a long period of time. It's a longer period of time is required, because this is by means of adverse possession. Another state has already been sovereignty over that territory. So that's why the second state is coming and exercising sovereignty, adversely affecting the original title of the first state. So that's why the concept of prescription itself is there must be some period of time. There should be longer period of time compared to occupation. So this is the main point for prescription. Okay. And that's why in this slide it's very clearly said that title by prescription, we need to establish both a stricter proof. The proof must be strict A longer period of display of state authority is required as compared to occupation. This is because the essence of prescription is the acquiescence of the one state in the adverse position of the other. The other means the original owner state. So the new state, the second state, is adversely taking possession of the territory which is already under the sovereignty of another state. So this one, there must be acquiescence. Acquiescence with the other, there no objection at all, no protest at all by the other state. Doctrine of acquiescence applies here in doctrine of prescription. So prescription is based on doctrine of acquiescence, acquiescence of the original owner state. Then only the new state can acquire title by means of prescription. So then what are the requirements of prescription? So the requirements of prescription are laid down in Kasikili Sadudu Island case by the decided by the ICJ. So there are 4 requirements. But although 4 requirements, the first 2 requirements, 1 and 2, are combined together. The first element of occupation, same as occupation, a little bit stricter only. The requirement is a bit stricter than requirements under the occupation. But it's combined together is explained about peaceful and continuous exercise of sovereign activities. This requirement is divided into 2, 1 and 2 under the requirements of prescription. Okay, let us see the number 1. The position must be exercised in the form of actual exercise of sovereign activity. Number 2, the position must be peaceful and uninterrupted. The same meaning. It must be peaceful, uninterrupted. Meaning that continuous. It must be peaceful and continuous. Peaceful here means there must not be any protest or objection by the former sovereign. In the case of occupation, even 1 or 2 protests doesn't affect the validity of occupation. But long protestation for consistent protestation may affect the validity of occupation. But in the case of the prescription, even 1 protest may affect the validity of prescription. No protest at all, no objection at all, because totally silent by the original owner state. That's why there must not be any protest or objection by the former sovereign. Display of state authority by the acquiring state is to be accompanied by acquiescence, as I told you before, doctrine of acquiescence on the part of the losing state. That's why this 1 and 2 combined together is same as the first element of occupation, but it is stricter. No protest at all, no objection at all by the former sovereign, and doctrine of acquiescence must be applied here. Then objection here mean what type of objections are valid? Objections may take the form of diplomatic protests. Through diplomatic channel, one foreign minister will complain against the foreign minister of another state. This is we call diplomatic protest. It is good objection. Chamizal arbitration case. And then statements in international organizations like United Nations General Assembly, Security Council, etc. And the enactment of national legislation applying to the territory. So not necessarily refer to a court or tribunal. No need to have any legal proceedings before a court or tribunal. Legal proceedings before a court or tribunal also very serious protestation. But it is not necessarily referral to a court or tribunal. The third requirement, the position must be public. It must not be in secret. It must not be clandestine, because there must be doctrine of acquiescence. That's why only when it is open and public, the other state may know that the third state is exercising sovereign activities. They know that then only they can protest. If they are secretly, not open, not public, then how can protest? So that's why the position must be public. It means that not secretly or not clandestine. Number 4, position must be for a certain length of time. In occupation, there is no length of time is prescribed by law. But in the case of prescription, length of time is prescribed. There must be certain length of time. But the length of time required is a matter of fact. It's a question of fact, depending on the facts of each and every particular case. But there must be long period of time. How long the period should be, it is a question of fact. Some say it should be around 40 years, 50 years, but no exact time required by international law. So these are the 4 requirements of prescription. Now we move on to the next mode of acquisition of territory, that is conquest. Conquest. What is conquest? Conquest is the taking possession of territory through military force in time of war. Military conquest. It must be by the use of military force in time of war, take possession of territory of another state. This is called conquest. And what was the law in the past? What was the practice in the past? After conquest, when the enemy was defeated, the conqueror finally annexed the enemy territory. So that's why conquest followed by annexation was regarded as a mode of acquiring territory. Conquest followed by annexation was regarded as a mode of acquiring territory in the past. This is the law in the past. Okay. So annexation means taking the territory and putting officially, legally in the province of the conquering state. This is called annexation. Annexation, occupation is different. For example, the British annexation of Malaysia. Malaysia was colonized, annexed by the British, and they put under the British Empire. This is annexation. But we use the term Japanese occupation. Japan just occupy Malaysia and do not put Malaysia under Japan, part of Japan. So this is occupation only. So that's why annexation, British annexation, Japanese occupation. So in the past, annexation of territory, this is colonization, was lawful. Use of force in the past was lawful. And then, by means of military force, taking possession of territory by means of military force was lawful. That's why colonialism in the past, in the old international law was lawful. But it is no longer lawful according to the modern international law. Why? Because of the United Nations Charter. So that's why today, conquest is no longer regarded as a lawful mode of acquisition of territory. This is, you have to take care of this one. Conquest is no longer regarded as a lawful mode of acquisition of territory. This is by virtue of the UN Charter. Because you know very well the UN Charter prohibits the use of force. Use of force is prohibited, and it's a rule of jus cogens. So that's why the main reference is Article 2, Clause 4 of the UN Charter. The use of force against the territorial integrity and political independence of a state is prohibited. This is a rule of jus cogens. That's why in the current time, no state can use military force against another state and acquire the territory of that other state. This is prohibited and this is unlawful. And this is also reaffirmed in the 1970 General Assembly Declaration of Principles of International Law. This is known as General Assembly Resolution 2625, and which is a very important resolution. And in the Nicaragua case, ICJ decided that this resolution, General Assembly Resolution 2625 1970, reflects customary international law. It means that although it is a General Assembly resolution, it is binding as customary international law, not as General Assembly resolution. And in this resolution, as far as territorial acquisition is concerned, it's a very important passage here which reflects customary law. The territory of a state shall not be the object of military occupation resulting from the use of force in contravention of the Charter. And the territory of a state shall not be the object of acquisition by another state resulting from the threat or use of force. No territorial acquisition resulting from the threat or use of force shall be recognized as legal. Not only it is illegal, other states also must not recognize this territorial acquisition by use of force as legal. Non-recognition of territorial acquisition by military force as legal. So this is important. And also we have one important case which can illustrate this point, that is Israeli occupation of Palestinian territories. Okay, in the next part 5, I will discuss in detail about this. Okay, thank you.